Hi, I'm Ross Simpson and I'm a solicitor in the Dispute Resolution and Litigation team at Shepherd and Wedderburn. In this section of our video series on handling disputes in Scotland, we look at expert evidence. The use of expert evidence or evidence of skilled witnesses is relied upon frequently in court cases in Scotland. Notwithstanding this, generally speaking, the Scottish courts currently exercise little judicial control over expert evidence. This differs quite substantially from the approach adopted in other jurisdictions like England, where there are specific sections of the civil procedure rules dedicated to expert evidence. In Scotland, it is for the parties to the action to decide between themselves matters such as whether the experts for either side should attend a joint meeting or prepare a joint report. In principle, it is not necessary to firstly obtain the consent of the court before leading expert evidence. If, however, a party wishes to be able to recover the cost of instructing expert evidence from the other side, then it is necessary to ask the court to certify that witness as a skilled person. There are exceptions to this general lack of judicial control in certain types of proceedings. In the commercial court, if you intend to rely on an expert report, you are expected to produce it as per the pre-action protocol that applies to commercial court actions. The commercial court is entitled to order that expert reports are lodged and can also order that experts should meet and prepare a joint report. The commercial court can also appoint its own expert. Another exception is in cases of professional negligence. In such cases, whether in the commercial court or otherwise, no action can be raised without first obtaining an expert report. In recognition of the typically low level of judicial control in this area, the Law Society of Scotland has published an Expert Witness Code of Practice. This provides guidance for solicitors and for experts. Amongst other things, the code sets out the type of information that the solicitor should provide when instructing an expert and the circumstances in which an expert should accept an instruction. The code notes that experts should maintain client confidentiality at all times and that any report prepared by the expert should be presented in plain English, with any technical terms explained. When giving evidence, an expert must bear in mind that, notwithstanding the fact that they are instructed on behalf of a certain party, their overriding purpose is to assist the court, and so they must remain independent of the parties. They must disclose any actual or potential conflict of interest which might influence their work for the client. Solicitors must assist the experts in maintaining their independence. For example, the code specifically notes that solicitors must not offer to make payment to the expert contingent upon the nature of the evidence given. The code is intended to be of general application, but does include advice on specialised areas of law. For example, where it is expert medical evidence that is sought, the code provides that client consent should be obtained before the expert is able to access medical records or carry out further medical examinations of the client. We hope you found this video on expert evidence of interest. For more information, visit our website or speak to your usual Shepherd and Wedderburn contact for advice.